In this part 26, we shall continue our discussion regarding security for keeping the peace and for good behavior. In the last part, we dealt with section 106 dealing with security for keeping the peace on conviction, section 107 security for keeping the peace in other cases, and section 108, 109 and 110 regarding regarding good behavior. Security with respect to good behavior from a person. What is the procedure that is required to be followed when the security for keeping the peace is required to be taken as far as section 107 is concerned, or for good behavior as per section 108, 109 and 110 is dealt right from section 111 onwards. If we start understanding section 111, it says, when a magistrate acting under section 107, section 108, section 109 or section 110 deems it necessary to require any person to show cause under such section, he shall make an order in writing setting forth the substance of the information received, the amount of the bond to be executed, the term for which it is to be enforced, and the number, character and class of sureties if any required. So this is the first condition, that order is required to be made. Magistrate has to make an order in writing, and this is a sort of a show cause notice to the person, as asking him as to why he should not be asked to execute a bond for keeping the peace or for maintaining good behavior. Now there are few possibilities. One, the person may be present in a court, and hence section 112 says, if the person in respect of whom such order is made is present in a court, it shall be read over to him, or if he so desires, the substance thereof shall be explained to him. If the person is not present in a court, section 113 says, summons or warrant in case of person not so present. If such person is not present in court, the magistrate shall issue a summons requiring him to appear, or when such person is in custody, a warrant directing the officer in whose custody he is to bring him before the court, provided that whenever it appears to such magistrate upon the report of the police officer or upon other information, the substance of which a report or information shall be recorded by the magistrate, that there is reason to fear the commission of a breach of peace, and that such breach of peace cannot be prevented otherwise than by the immediate arrest of such person, the magistrate may at any time issue a warrant for his arrest. Now every summons or warrant issued under section 113 shall be accompanied by a copy of the order made under section 111, and such copy shall be delivered by the officer serving or executing such summons or warrant to the person served with or arrested under the same, as laid down by section 114. The magistrate may, if he sees sufficient cause, dispense with the personal attendance of any person called upon to show cause why he should not be ordered to execute a bond for keeping the peace or for good behavior, and may permit him to appear by a pleader. So as per section 115, magistrate has got power to dispense with personal attendance. During course of learning criminal procedure code, we will come across section 205. where magistrate can dispense with the personal appearance. Whereas when we will read section 273, we will come across that evidence is required to be recorded in presence of the court unless it is dispensed with. And then when we dealt with form number 30 as far as second schedule of the criminal procedure code is concerned, where a special summons is issued in case of petty offences. So one can understand form number 30 as far as summons is concerned when it is read along with section 206 of the criminal procedure code. With this now, the magistrate has to conduct to find out as to whether there is truth as far as the information which is received by him is concerned, and elaborate procedure is laid down as far as inquiry is concerned as far as section 116 is concerned. It says, when an order under section 111 has been read or explained under section 112 to a person present in a court, or when any person appears or is brought before a magistrate in compliance with or in execution of a summons or warrant issued under section 113, the magistrate shall proceed to inquire into the truth of the information upon which action has been taken, and to take such further evidence as may appear necessary. Such inquiry shall be made as nearly as may be practicable in the manner hereinafter prescribed for conducting trial and recording evidence in summons cases with which we shall be dealing as far as the trial procedure is concerned when we start discussing right from section 251 up to section 259 of the criminal procedure code. After the commencement and before the completion of the inquiry under subsection 1, the magistrate, if he considers that immediate measures are necessary for the prevention of a breach of peace or disturbance of the public tranquility or the commission of any offense or for public safety, may, for reasons to be recorded in writing, direct the person in respect of whom the order under section 111 has been made to execute a bond with or without sureties for keeping the peace or maintaining good behavior until the conclusion of the inquiry, and may detain him in custody until such bond is executed or in default of execution until the inquiry is concluded, provided that no person against whom proceedings are not being taken under section 108, section 109 or 110 shall be directed to execute a bond for maintaining good behavior. The conditions of such bond, whether as to the amount thereof or as to the provisions of sureties or the number thereof or the pecuniary extent of their liability, shall not be more onerous than those specified in the order under section 111. For the purposes of this section, the fact that a person is an habitual offender or is so desperate and dangerous as to render his being at large without security hazardous to the community may be proved by evidence of general repute or otherwise. Where two or more persons have been associated together in the matter under inquiry, they may be dealt with in the same or separate inquiries as the magistrate shall think just. The inquiry under this section shall be completed within a period of 6 months from the date of its commencement, and if such inquiry is not so completed, the proceeding under this chapter shall on the expiry of the said period stand terminated unless for special reasons to be recorded in writing the magistrate otherwise directs. Provided that where any person has been kept in detention pending such inquiry, the proceedings against that person, unless terminated earlier, shall stand terminated on the expiry of the period of 6 months of such detention. where any direction is made under subsection 6 permitting the continuance of the proceedings, the session judge may, on the application made to him by the aggrieved party, vacate such direction if he is satisfied that it was not based on any special reason or was perverse. Now, what is the order that will be passed after the inquiry? And as per section 107, if upon such inquiry it is proved that it is necessary for keeping the peace or maintaining good behavior as the case may be, that the person in respect to whom the inquiry is made should execute a bond with or without sureties, the magistrate shall make an order accordingly, provided no person shall be ordered to give security of a nature different from, or of an amount larger than, or for a period longer than that specified in the order made under section 111. The amount of every bond shall be fixed with due regard to the circumstances of the case and shall not be excessive. When the person in respect of whom the inquiry is made is a minor, the bond shall be executed only by his sureties. As per section 118, if on an inquiry under section 116 it is not proved that it is necessary for keeping the peace or maintaining good behavior as the case may be, that the person in respect of whom the inquiry is made should execute a bond, the magistrate shall make an inquiry on the bond to that effect, and if such person is in custody only for the purposes of inquiry, shall release him, or if such person is not in custody, shall discharge him. With this now, section 119 speaks about commencement of the period for which security is required. If any person in respect of whom an order requiring security is made under section 106 or section 117 is at the time of such order is made sentenced to or undergoing a sentence of imprisonment, the period for which such security is required shall commence on the expiration of such sentence. In other cases, such period shall commence on the date of such order unless the magistrate, for sufficient reason, fixes a later date. Now, the bond to be executed by any such person shall bind him to keep the peace or be of good behavior as the case may be, and in the latter case, the commission or attempt to commit or the abatement of any offence punishable with imprisonment, wherever it may be committed, is a breach of the bond. Now the magistrate has got power to reject sureties. A magistrate may refuse to accept any surety offered, or may reject any surety previously accepted by him or his predecessor under this chapter on the ground that surety is an unfit person for the purposes of the bond, provided that before so refusing to accept or rejecting any such surety, he shall either himself hold an inquiry on oath into the fitness of the surety, or cause such inquiry to be held and a report to be made thereon by magistrate subordinate to him. Such magistrate shall, before holding the inquiry, give reasonable notice to the surety and to the person by whom the surety was offered, and shall, making the inquiry, record the substance of the evidence adduced before him. So, with this now, the next part, that is, if the magistrate is satisfied after considering the evidence to adduce either before him or before a magistrate deputed under subsection 1, and the report of such magistrate, if any, that the surety is an unfit person For the purposes of the bond, he shall make an order refusing to accept or rejecting as the case may be, such surety recording his reasons for doing so, provided that before making an order rejecting any surety who has previously been accepted, the magistrate shall issue him summons or warrant as he thinks fit, and cause the person for whom the surety is bound to appear or to be brought before him. Now, in case there is default as far as security is concerned, the magistrate has got power to ask person to undergo imprisonment. If any person ordered to give security under section 106 or section 107 does not give such security on or before the date on which the period for which the security is to be given commences, he shall, except in a case next hereinafter mentioned, be committed to prison, or if he is already in prison, be detained in prison until such period expires, or until within such period he gives the security to court or magistrate who made the order requiring it. Now, this, if you go through section 122 in detail, which is very lengthy section, it speaks about the procedure that is required to be followed. And if you read subclause 7, which says, imprisonment for failure to give security for keeping the peace shall be simple. Subclause 8 says, imprisonment for failure to give security for good behavior shall, where the proceedings have been taken under section 108, be simple, and where the proceedings have been taken under section 109 or section 110 be rigorous or simple, as the court or magistrate in each case directs. With this now, magistrate has got power to release person imprisoned for failing to give security is dealt as far as section 123 is concerned, and security for unexpired period of bond is laid down as far as section 124 of the Criminal Procedure Code is concerned. With this now, we have dealt with security for keeping the peace and good behavior right from section 106 up to 124. And now this is the time for us to start discussing with the next chapter, namely chapter 9 of the Criminal Procedure Code, which to certain extent is substantive in the nature. And the heading of the chapter is Order for Maintenance of Wives, Children and Parents. Now, if you start reading this right from section 125 to 128, if you read section 125, we will try to understand as to who can make an application as per section 125 of the Criminal Procedure Code. At the same time, we learn against whom this application is made. The further part, in order to consider this application, what are the conditions that are required to be fulfilled is dealt by the same section. For example, a person who makes an application must be unable to maintain himself or herself. The person against whom the application is made must have sufficient means, and the application is maintainable only when there is neglect or refusal on the part of the person who is bound by law to maintain him. And hence, this is the time, as I told you, we come to know what is the duty of a person, and the duty of the person is to maintain and if he fails in his duty, there starts his liability as far as this section 125 is concerned, with which we have to deal. Now, what is as we proceed further, what is which is the court that has got jurisdiction, and what is the procedure that is required to be followed, is dealt as far as section 126 is concerned. With this now, the next section, namely section 127, makes a provision as to once an order of maintenance is passed by the court of law, there can be alteration with respect to the amount or alteration in the allowance as far as section 127 is concerned. And the last section, as far as this chapter is concerned, they speaks about how this order that is passed by the court of law is required to be enforced, and enforcement of order of maintenance is dealt as far as section 128 of the same chapter is concerned. So now once we start discussing section 125, it says, if any person having sufficient means neglects or refuses to maintain his wife, unable to maintain herself, his legitimate or illegitimate minor child, whether married or not, unable to maintain itself, or his legitimate or illegitimate child, not being a married daughter, who has attained majority, where such child is, by reason of any physical or mental abnormality or injury, unable to maintain itself, or his father or mother unable to maintain himself or herself. A magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife or such child, father or mother, at such monthly rate as the magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct, provided that the magistrate may order the father of a minor female child referred to in subclause B to make such allowance until she attains her majority, if the magistrate is satisfied that the husband of such minor female child, if married, is not possessed of the sufficient means. Provided further that the magistrate may, during the pendency of the proceedings regarding monthly allowance for the maintenance under this subsection, order such person to make a monthly allowance for the interim maintenance of his wife or such child, father or mother, at the expenses of such proceedings which the magistrate considers reasonable, and to pay the same to such person as the magistrate may from time to time direct. Provided also that an application for the monthly allowance for the interim maintenance and expenses for proceedings under the second proviso shall as far as possible be disposed of within 60 days from the date of service of notice of the application to such person. And then if you try to understand who is minor for the purpose of this chapter, it says minor means a person who is under the provisions of the Indian Majority Act 1875 is deemed not to have attained majority. And as far as definition of wife is concerned, it says wife includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried. Any such allowance for the maintenance or interim maintenance and the expenses for proceedings shall be payable from the date of the order, or if so ordered, from the date of the application for maintenance or interim maintenance and the expenses of proceedings as the case may be. If any person so ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole or any part of it each month's allowance for maintenance or interim maintenance and the expenses of the proceedings as the case may be, remaining unpaid after the execution of the warrant, to imprisonment for a term which may extend to 1 month or until payment if sooner made, provided that no warrant shall be issued for the recovery of any amount due under this section unless the application be made to the court to levy such amount within a period of 1 year from the date on which it became due. Provided further that if such person offers to maintain his wife on a condition of her having with him, and she refuses to live with him, such magistrate may consider any grounds of refusal stated by her and may make an order under this section notwithstanding such offer, if he is satisfied that there is just ground for doing so. If the husband has contracted a marriage with another woman or keeps a mistress, it shall be considered to be just ground for his wife's refusal to live with him. No wife shall be entitled to receive an allowance for the maintenance or interim maintenance and the expenses of the proceedings as the case may be from her husband under this section if she is living in adultery, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. On the proof that any wife in whose favor an order has been made under this section is living in adultery, or that without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate shall cancel the order accordingly. Now, the section proceedings under this section, namely 125, may be taken against any person in any district where he is, or where he or his wife resides, or where he last resided with his wife as the case may be, with the mother or the illegitimate child. All evidence in such proceedings shall be taken in presence of the person against whom an order for payment of maintenance is proposed to be made, or when his personal attendance is dispensed with, in presence of his pleader, and shall be recorded in the manner prescribed for summons cases. Provided that if the magistrate is satisfied that the person against whom an order for payment of maintenance is proposed to be made is wilfully avoiding service or wilfully neglecting to attend the court, the magistrate may proceed to hear and determine the case ex parte, and any order so made may be set aside for good cause shown on an application made within 3 months from the date thereof, subject to such terms, including terms as to payment of costs to the opposite party as the magistrate may think just and proper. The court, in dealing with application under section 125, shall have power to make such order as to cost as may be just. Now, on proof of change in the circumstances of any person receiving under this section a monthly allowance for the maintenance or interim maintenance, or order under the same section to pay a monthly allowance for the maintenance or interim maintenance to his wife, child, father, mother, or as the case may be, the magistrate may make such alteration as he thinks fit in the allowance for the maintenance or in the interim maintenance as the case may be, provided that if he increases the allowance, the monthly rate as mentioned it shall not be exceeded accordingly. Now, with this, this section speaks about alteration as far as the order that has been passed by the court of judicial magistrate first class is concerned, and then the details are enumerated as far as rest of the part. If you have reading of this section, that will serve the purpose from the point of view of understanding the same. But then last part, namely when we talk about enforcement of order of maintenance, it says a copy of the order of maintenance or interim maintenance and expenses of proceedings as the case may be shall be given without payment to the person in whose favor it is made, or to his guardian if any, or to the person to whom the allowance for the maintenance or allowance for the interim maintenance and the expenses of the proceedings as the case may be is to be paid. And such order may be enforced by any magistrate in any place where the person against whom it is made may be, or such magistrate being satisfied as to the identity of the parties and the non-payment of the allowance, or as the case may be, expenses due. So this is regarding the substantive provision as which is laid down as far as criminal procedure code is concerned, where a court of judicial magistrate first class has got power to ask a person to pay maintenance if the conditions are satisfied as far as section 125 onwards as far as this chapter is concerned. With this now, in the next lecture, we will try to understand as to the next preventive measure, namely maintenance of public order and tranquility, right from section 129 up to section 148. The lengthy chapter, there are many provisions, and hence if you read, then it becomes very easy for us to understand, and hence as soon as we finish with that, once we start right from section 154 onwards, we shall be starting with the criminal procedure code in the real sense of the term.